That's very good. Now we'll go to the Criminal Lawyers Association and London-Weinstein for 10 minutes.
Good morning. Thank you very much to the Chair and to the committee for inviting the Criminal Lawyers Association to speak this morning on this very important act. I'm a former director of the Criminal Lawyers Association and president of the Defence Counsel Association of Ottawa. I'm also have been a practicing criminal lawyer for almost 20 years, and I'm an adjunct professor at the University of Ottawa Law School. I'd like to say at the outset that the objectives and goals of this bill are laudable, that being the protection of public health and public safety by establishing strict product safety and product quality requirements, and reducing the burden which marijuana offences currently place on our criminal justice system. We know that Canada has a high relative marijuana usage. We also know that there's a real likelihood at some point that young persons may experiment with marijuana. Given these two inescapable facts, it makes good sense to move toward removing the stigma associated with cannabis for Canadians. Reading through this act, which is quite dense and detailed, one senses that while the act does eliminate many of the stigmatizing aspects of marijuana use, the drafters of the act still drew fairly heavily on the criminal law as a method to enforce regulation. In my view, it would be preferable to avoid reliance on the criminal law and criminal sanction as a method of ensuring compliance with what should be a largely regulatory piece of legislation for what should be a legal product. We know from criminology experts like Professor Anthony Dube and Rosemary Gartner from the University of Toronto's Centre for Criminology and Socio-Legal Studies that imprisonment does not deter crime any more effectively than less harsh sentences. What deters crime, we know definitively, is certainty of detection. We also know that persons who are sent to prison are not less likely to reoffend than similar people who manage to get a sentence not involving prison. Despite these findings, persons are sentenced to lengthy periods of incarceration because we are unable as a society to craft sentences which adequately reflect the seriousness of the behavior. We also know that children of parents who are imprisoned are more likely to end up running afoul of the law themselves. Other collateral effects of the imprisonment of a parent is the fact that children of these parents are more likely to become homeless, to live in poverty, and those are just a few of the collateral effects of the imposition of a criminal sentence and a jail sentence for possession or distribution of cannabis. The use of the criminal law to enforce adherence to the regulations of the Act also puts young persons at risk of a criminal charge. Even though it's one under the YCGA, it can result in a period of closed custody, and it is a serious and significant impact on a young person's life that we really need to think about seriously when we're talking about a product like marijuana, and knowing we want to discourage young people from experimenting with this drug, but knowing that in all likelihood some of them will, and we want them to avoid the worst consequences of experimentation, that being drawn into the system. As Mr. Levesque pointed out, there's an anomalous segment of the Act in that an adult who can actually be in possession of more dried marijuana than a child, which means that a child would actually be more vulnerable to criminal sanction or being caught up by the criminal law than an adult would, which I suggest, is somewhat anomalous, because an adult should be more morally culpable than a child, even though it's clear that the Act is trying to discourage children from possessing larger quantities of marijuana. Making them more vulnerable to criminal sanction is not the way. Another significant problem, in my view, exists in the structure of the ticketing provision of the Act, given that all discretion as to whether a person will be prosecuted under the Criminal Code or the Controlled Drugs and Substances Act, or merely given a ticket, is vested in the discretion of police, with very few actual concrete guidelines in the Act sort of giving direction for how police should act, and similarly how prosecutors should exercise their discretion as to whether proceed by indictment or whether to proceed summarily, which would result in a lesser consequence. If the purpose of potential criminal sanction is to deter deviation from the Act, in other words, to take away the black market, to eliminate organized crime, and to discourage people from acting outside of the Act, a ticketing option where it's not known in advance to the public whether you're going to be prosecuted under the criminal code criminally or whether you're going to get a ticket means that the law is not going to be certain to people. The outcome is not going to be certain, And that vagueness or the uncertainty of the outcome undermines the stated purpose of the ticketing provision and the use of the criminal law. We want the law to be consistently known in order that it can be consistently followed. Vesting all of the discretion as to whether someone will get a ticket or a criminal prosecution with police and without guidance will result in an uneven exercise of discretion. And there's a great example in existing legislation under the YCGA today. That statute allows specific procedures relating to alternative measures for young persons. Section 6.1 of the YCGA directs police officers to consider whether alternative measures are appropriate. They can take no action, issue a warning or caution, or refer the young person to an appropriate program or agency. However, the reliance, in my experience, on these pre-charge diversion programs varies by officer to officer. Some officers know of these provisions of the YCGA and offer them to young persons, but many do not, nor do they have any idea what criteria should be exercised to inform the decision whether to offer the diversion or not. So we can see through a statute that we already have that leaving the discretion solely to the officer can result in an uneven application of the law. And we also know that Indigenous persons are traditionally overrepresented in the criminal justice system. An enforcement system which rests solely within the exercise of discretion without guidance from the statute will inevitably result in those who are traditionally overrepresented in the system continuing in that pattern. There's also, and I believe Mr. Spratt touched on this yesterday, a potential scenario where an 18-year-old passing a joint to a younger teen could be exposed to a lengthy sentence as a result of providing marijuana to a young person. In relation to the factors relating to sentence, I would note that the sentencing provisions which are set out in Section 15.2 describe as an aggravating factor being in or near any public place usually frequented by young persons. There's a similar term that's contained in the Controlled Drugs and Substances Act. In my view, this is an overly broad term which is going to be subject to a potential Section 7 challenge. In my dealings with prosecutors who deal with this act under the CDSA, they are very reluctant to sort of take it to court and defend a constitutional challenge because in my view it's going to be vulnerable to a challenge as being overly broad. As a public place where young persons might be can constitute just about anywhere. I would like to point out that Section 15.4, however, which is a provision which allows a judge to adjourn sentencing in order to allow an individual to seek rehabilitation prior to sentence, which is something our judges frequently do anyway, but having it codified in the Act is an encouraging sign, is a worthwhile provision, placing an emphasis on the Act on rehabilitation. So just in conclusion, I'd like to say that the Act is a good step forward. It has many laudable objectives, not the least of which is the protection of public health and the protection of children, the discouragement of organized crime in drug production and supply, but resort to the criminal sanction for a product which is subject to legislative regulation is always going to present challenges in maintaining proportionality, especially where it exposes young persons to the threat of criminal proceedings. It's also unclear what effect a conviction under the ticketing system will have on travel, particularly to the U.S., police clearance sheets, and employment, or whether it will be considered a prior drug offense for other offenses. Canadians who choose to plead guilty by way of sending off a ticket in the mail should be aware of the potential collateral consequences which may arise. Thank you very much.